old text messages.
Right. Okay, so when was that statement that I'm going to shoot up the house and yada, yada, yada? Sure, take your time.
And Judge, while they're looking, it's not alleged when the statement was. And not only that, it's not reported till 3 days later. Furthermore, in the reviewing the text messages that have been submitted, there's not a single text message that has that specific threat in it.
Well, I don't know. I mean, it's the state's burden to show, I don't know, but terroristic threat has to be an immediate fear of harm.
So I don't see an actual date in the offense report. I personally have not reviewed the text messages in this case, Judge. I don't see a date of the actual threat.
That's not a good thing. I mean, who knows when that statement was made? Could have been made 2 years ago. Could have been made yesterday. Yeah, I agree with you, man. I mean, if you don't have anything else, then that's it. Okay, I'm going to find no probable cause. Mr. McCollum, we're not asking much, man. We want our streets to be safe. I'm going to do everything in my power to protect the streets, right? If I find that you're a problem, if they call back and it continues to happen, it's not going to go well. Life is way too short to live in a 6x9 box. There are a lot of great people in life. There's a lot of bad people in life. And if you have a relationship with a so-called person that brings out the worst in you, then don't have a relationship with this person. There's a gajillion and one fish in the sea. It's not worth it to have someone rap you so bad that you make and say things that make you go to jail. It's not worth it. Do you understand? Now, don't have contact with this person because it's just not going to end well. All right? All right. So I'm going to continue bond. I'm not going to revoke your bond on this case now because I'm finding no probable cause, but just behave. It's not hard. Be nice. All right. Okay.
Judge.
For sure. Felicia.
Yes, Judge.
We ordered him to have a GPS monitor.
Yes, Judge.
We admonished you last time that there was absolutely zero tolerance. And now we have a third bond violation. What was the nature of this violation, please?
So it's that we lost cell on it, so either it wasn't charged properly or something of the nature. It's just.
So he had a dead battery.
Yes. And
How long?
I'm sorry. I'm sorry, Judge.
Take your time. I'm in no rush.
If I may, if you would be willing to admonish the defendant as well. I spoke to the complainant yesterday, and apparently the defendant has been making posts about her on social media, bribing people with money to hurt her, and she's pregnant with their child.
Judge, this complaining witness has been sending a bunch of messages to my client. She's been harassing him. I actually advise.
Show me.
I advise.
Show me.
I did ask her to send me screenshots and everything, Judge, and she said
We'll have a hearing. Show me. We'll have a hearing. Show me what you got. We'll have a hearing over it. But all I know is this is your third bond violation. I'm not happy with you, Mr. McCollum.
Judge, I saw that I don't think it turned back on at all from what I'm seeing on my end. But whenever he did report yesterday to have the device inspected, and they did just tell me that he did receive a new charger and new device.
When did it die? What's the date?
14th.
So from the 14th to today, when he got it back on, it's been dead.
He got it on yesterday, Judge.
Yes.
But it was on
To
yesterday.
the 17th. It's been dead for 3 days.
He called me yesterday and told me to go to pretrial and check out, because they
Your
gave me.
device has been dead since December 14th. And
Aware of that, sir. I never knew they didn't give me no text or nothing. I was unaware of thinking it's charging. They gave me a new
And Judge,
charger.
Judge, with all due respect, he went there on Monday. They gave him a new charger and a new device. So it seems to me that it's a technical issue. So Judge,
you're supposed to charge it on a daily basis. Am I,
Even in the pretrial, they charged it and they seen that it was charging, but it was still something messed up with the charger. So they gave me a whole new thing again. They gave me a new
how
charger.
often is he supposed to charge it?
I think they're advised to charge once a day for at least an hour.
I'm not buying it. I'm sorry, Hunter. He goes with you. No. This is a third violation, Mr. McCollum. It's not going to continue to happen.
Judge, with all due
I
respect,
have-
this is a technical violation. He shouldn't have to go into custody.
It's a third violation, Hunter.
My second, sir. It's my
Judge,
second.
it's
the first
clearly,
time.
just please stop talking. Let me talk. Judge, it's clearly that there was an equipment issue. Otherwise, they wouldn't have replaced the equipment. So I don't see how.
It'd be an excuse, Hunter, the minute you have an issue, you're supposed to go get it serviced, not 3 days later. This is a third stop. This is a third violation. And I told you the last time when you were here with the baby that there was absolutely no tolerance, that you were supposed to live to the conditions. 100, it's been dead for 3 days.
I was unaware of that, sir. So when they called me.
Goes with you. Sorry, I'm not going to entertain excuses. It's zero
I'm not
tolerance.
giving you an excuse, sir. They gave me a new charger and a new monitor.
Judge.
It's not like I didn't mess up anything. As soon as they called me, I
Come on, talk to your attorney.
Judge, would you allow me to escort him up to felony court so that he can go take his plea today? The whole reason they had set the plea to after the holidays is so that he could do it after the holidays. And I believe part of this deal would see this case go away, and he's gonna be on probation for 2 years upstairs. So I really don't see the benefit to
I mean,
society.
if you want to go see if that's something that you guys can work upstairs, I can ask if they'll escort him upstairs. But I can't continue to play this game, Hunter.
I understand,
You know,
Judge.
I mean, really, we ask you over and over and over to comply. I'm not asking for much,
I
right?
understand,
And
Judge.
it's been dead for 3 days. You know it's been dead because you're supposed to charge it. So you're supposed to charge it on a daily basis. So for you to come here and tell me I didn't know, it's disingenuous. It's just not true. So, but
My
I'm
frustration
happy
as
to
a
acquiesce.
attorney is I've seen this with multiple clients where there are technical issues that happen with these devices. I've seen it with multiple clients where they're unable to charge.
Hey, if you see it on the 14th that you have issues, then you go immediately. You don't wait 3 to 4 days later, especially when you've had violation after violation after violation. I think that your complaining witness may be here too. Rosette, CW may be here as well.
Judge, I'm not sure.
So I don't know, Hunter, just,
I believe that's for a judge.
okay, ma'am, please don't. If you want to,
I think pretrial has something to say. I don't know what they have to
I
say.
reached out to my supervisor of these devices just because I'm not super well versed in the GPS realm, but he stated that the reports for his GPS appear to show an issue with overcharging, which can lead to a charger problem. They're instructed to charge for 1 full hour on the same time each day, and that the tech swapped his device as a precaution as it was likely that malfunctioning.
but why wait 3 days? You know the device is malfunctioning on the 14th. You're going to wait 3 days to go get it fixed?
I was just informing of what my supervisor told me because I asked somebody to look over the report.
I don't know what to tell you,
I
Hunter.
mean, Judge, it
You know.
sounds like he was overcharging. He was doing more than prior.
No,
So
we don't know that for sure. I don't know. See what documents that you can show me, that you can get that there's some kind of malfunction. But nevertheless, it's a third violation. On the 14th, if he has issues, perhaps even go the next day on the 15th. But you wait 3 days. And the only reason he did it is because I hauled him into court and I told him to be here on the 18th. Otherwise, who knows what would have happened? See what you can find and then show me. I'm all eyes.
Well, Judge, the other thing I would ask is if you are going to take him into custody, I'd ask for a formal hearing to be set. And since this was set within less than 24 hours, I do believe it violates his due process to go ahead and take him into custody today. Yeah,
Just show me what you can find, Hunter. You know, Eddie.
Judge, real quick, Judge.
Right. Okay. Get what records you can. Show me something.
Okay.
Guys, are you ready?
Yes, Judge.
There are times in life when you run into people, they can be a complete cancer to your life. Some people thrive on drama. That's how they get off. That's all they like. They like to just create. If you have people in your life like that, it's probably advisable to cut ties, because if not, they're just going to bring you down. We all have people like that in our life. We do. I do. I have people that are constantly after me as well. I do everything in my power to get away so that it doesn't bring you down. The problem is, Mr. McCollum, is when we have situations where there are repeated bond violations, I take issue with that. And I can't let people go when they continue to have violations. But I want to know that it's a true violation. I have ordered him not to have contact with this person, correct?
Now, this is the moment everything shifts. The judge is no longer discussing the terroristic threat. She's focused on bond violations, and this is a third one. Legally, bond conditions are not suggestions. They are court orders. When a defendant is placed on GPS monitoring, compliance must be strict. A dead battery for 3 days raises serious concerns because monitoring is meant to provide continuous supervision. The defense argues it's a technical malfunction, even mentioning device replacement. But here's the issue. If the device stops working, the responsibility is still on the defendant to report it immediately. Waiting days creates a gap in supervision, and that undermines the court's trust. Ask yourself, if someone has already violated bond multiple times, how much benefit of the doubt should they get? This isn't just about a charger. It's about credibility. And credibility is everything when freedom is on the line. Let's go back to the judge's response.
I'm not asking much from you. The only thing I'm asking you to do is stay out of trouble, keep your monitor on, and don't have contact. You stop. I'm not asking you to say, I don't like to put in jail, but I got to know that you're complying with the conditions. There's a lot of things that are at play in your case here. There's a lot of other evidence that's out there that I would like to see before I take action and put you in. They're saying things that happen. Hunter is saying things that happen. I want to know what the truth is. And the truth is, and it lies with the evidence, because the evidence will point to whose side is correct. Words, Mr. McCollum, words mean absolutely nothing. I don't give a rat's ass about words. Evidence points to whose side is correct. I am going to give you some time, not a lot, but I'm giving you to Friday to figure out what's going on, because I want to know. Most importantly, is it the machine that's messing up? Are you truly charging it? Number one. Number two, they're saying that there's been contact. I hope not. I want to know. I want to see it. Show me what you have. Likewise, show me what you have too. I'm all ears. I'm giving you the benefit of the doubt right now. If I wasn't, I would lock your butt up right now. But I'm giving you the opportunity now to show me what evidence is out there. Show me what you're doing. I want to know, are you charging this device as it should be? There are records of this. You know what the expectation is. I'm giving you time, Mr. McCollum, and I'm giving you the opportunity. I want to see it. Likewise, I want to see in what validation they have as well. That's it. We will reconvene here Friday because I want to know what Hunter has. I want to know what they have. Is that enough time?
Yes, Judge. Friday's fine.
Do you have any questions? You know what? It's better not that you don't. If you have any questions, talk to Hunter. But I'm giving you the opportunity. All I want to know is, are you abiding by it? Are you abiding? That's all I want to know. Okay. See you Friday. Mr. Manzano.
Yes, sir.
I brought you into court because I have bond violations yet again. Is this a third violation? Please.
May I be heard on that, Judge?
Absolutely. I just want to make sure that it is, if I'm remembering correctly, it is a third violation.
Okay. Initially, I have a pre-hearing motion for continuance, Judge. I like to have time to prepare for this. This is not a normal allegation of 19 skip tests. This young man works as a machine operator. Every day he's gone to work. This machine that he operates could cause injury to himself or to others if he is operating while intoxicated. Once we get all the work records, Judge, we could show you that there was never any reprimand, any suspension, anything from work that cause you to believe that he was operating the machine while intoxicated. In addition, Judge, I like to subpoena Smart Start records. He attempted to go over there yesterday to get records, but of course, they just gave him a 1-800 number, and then they said, well, we'll send it to you in about a week. So, Judge, this is very questionable whether or not he skipped 19 tests. In reference to the third violation, this is the third violation that pretrial filed, but the first one was that when he was released from court, he went to pretrial and he thought pretrial was going to call him up to give him the information of where to go to get the ignition interlock. He never got that information. He was confused. And as soon as I received that email about him not having the portable device, I informed him within 5 or 6 days he had it. He's very responsible, Judge, for what he is charged with.
All I know.
Secondly, Judge, that second one, it's totally shouldn't be given any credit. This is the one that he was given a drug test. He went and took his drug test. 2 days later, they notified him to come back and give another drug test.
I got it. I understand. And I certainly won't take that into account, Jesse. But I'm going to tell you now, we have here from November 27th, 2024 to December 17th, we have 19 skip tests.
Quiet, please.
Unacceptable if this is true. Unacceptable.
I agree 100% if it's true, Judge.
So let's do this. I'm not going to give you a lot of time, but I can give you, up to a week. We can have a hearing on this next Thursday if you'd like. And
These next 2 days, I'm not available,
records
Judge.
that you want.
Next 2 days, I'm not available. I've got my funeral going on, and we're about to leave shortly. It's in Sugar Land, and we're going to be there all day. And tomorrow at 10 o'clock, it's going to repeat. And Friday, I've got to be at the bond hearing in Montgomery County. If you allow me, Judge, I need to get records from both the company and from Smart Start.
I have those records to you today, Jesse.
For the violation date.
The only thing I received was the allegations.
I mean, we will send you the allegation. I will send you every piece of record that we can muster up to get to you, but I'm not setting this out 2 weeks for a bond hearing. And not when we're skipping tests like crazy. I will give you a reasonable amount of time, but I'm not going 2 weeks.
May I offer a suggestion,
Judge, the coordinator is going to be out next week and I'll be coordinating. So can we do it on
I'm not doing 2 weeks. This is a bond violation hearing.
May I make a suggestion, Judge? Why don't we put a ankle monitor on him? There's no way he could skip that. If we put that on, then you know if he's consuming anything.
Okay, Jesse. Just because we love you.
I love you
put the
too,
ankle
Judge.
monitor on. But I'm going to tell you now, if I get any violation, and I don't care how minute it is.
What we've just witnessed is a judge walking a very careful line between accountability and fairness. In the first matter, she refused to stretch the law without clear evidence and found no probable cause. But in the bond violation hearings, her tone shifts. Repeated violations, skip tests, and monitoring issues are not minor technicalities. They directly impact public safety and court integrity. Still, instead of immediately revoking bond, the judge demands evidence. She gives the defense a short window to produce records, GPS data, and Smart Start documentation. That's due process in action. She makes one thing crystal clear. Words don't matter. Evidence does. And if the evidence supports the violations, consequences will follow. This courtroom isn't running on emotion. It's running on proof.
I'm going to grow horns and a freaking tail. Do you understand? You better look at every single thing that you put in your body, when you put it in, what it is. I don't care what holiday it is, and I don't care who you're with. You get a hot violation on that thing, I'm going to be hot. You understand? There's absolutely no excuse, Jesse, and I will not entertain anything if it goes hot.
I understand that, Judge.
All right, you get it today. No more excuses.
And then someone should be sending the portable report for